Corruption is a widespread problem across the world. But for Nigeria, corruption has eaten deep into the roots of various institutions and arms of government. The Buhari-led administration came into power with the intention to fully fight corruption and prosecute those found guilty. But so far, not many corruption cases have been followed through to conclusion. This has been due to a number of reasons in the Nigerian judicial system. One factor that has delayed the logical conclusion of many cases is the antics played by accused persons to evade justice in many cases. It appears that probing Nigerians with cases to answer has resulted in some of them feigning illnesses and suddenly taking ill. Some have even mastered the art of fainting, using neck braces and using crutches to show the severity of their conditions. So many Nigerians have acted this script in a bid to delay answering to the law. So what do you think about this? So joining me in the studio to discuss this is lawyer Olutunbosun Oshifora to help us make sense of all of this from the eyes of the law. Good morning, Bosun.
Good morning. Always a pleasure.
You're welcome. Very fine. And now the point there is, since the last decade, I must say, the last decade has seen a lot of drama, you know, from persons, either people who were governors or people who were lawmakers or government officials at one point or the other. After their tenures, you know, they are called to answer one or two questions and then drama ensues. Oh, I'm not feeling well, you know. We see pictures, we see videos, we see drama of all kinds. Talk to us basically. Why is this happening? And in the eyes of the law, where do all these stand?
Okay, I think we should start like this. One, anytime there is prosecution or somebody is involved in a crime, and then the authorities come after the person and they charge this person to court, there's an essence of the law, there's a spirit of the law. What you're aiming to achieve is not necessarily to do anything other than recover what has been taken by this person and also make sure that the person faces the wrath of the law. Now, but there is prosecution, it is not aimed at persecution. Okay. Now, so, and in the course of doing this, the provisions of the law, if you look at section 36 of the 1999 Constitution, it says that anybody who is charged with an offense is presumed innocent exactly, until proven guilty. So in the course of prosecuting that person for a particular crime, you have to be careful. You have to be circumspect in your dealings. So you don't assume the person is guilty, regardless of the facts and evidence available to you, until the court says otherwise. It is only the court. I mean, there are a lot of cases that the court has given vent to that position, that it is only a court of competent jurisdiction that can actually declare anybody facing criminal charges as a criminal. So, and not even a judicial panel could do that. It's only a court of competent jurisdiction that could do that. So in the course of prosecuting that person, there are a lot of things, a lot of factors that come to bear, that come to play. Now, so that's the cardinal point, is the one that I just said earlier, that the person is innocent until proven guilty. Now, so you're trying to establish the crime. You're not trying to kill the person or muzzle the person or destroy the person. So once crime has been established, then the court can go ahead with sentencing and all the ancillary things that come with it. Now, so, but in the course of it also, your rights are intact. Your fundamental rights are intact. From arrest or invite or invitation to the final point where judgment is given, all your rights are supposed to be intact. Now, one of the rights that the Constitution avails you, the 1999 Constitution as amended, if you look at Section 35, it talks about, Section 35 talks about liberty, personal liberty. Everybody is entitled to personal liberty. I can't just hold you in the name of the law and hound you and do as I wish to you. Though there are exceptions, but everybody is entitled to personal liberty. It's a fundamental right, and it should not be tampered with.
All right. Now, let's talk about these exceptions, because we've seen cases where someone is said, okay, is told, okay, you have a case in court, so you need to just be in court on certain days. But we also see cases where people are detained for a period of time, then they are expected to be brought from their places of detention, either under EFCC or under NDLE or under the whatever the thing is, you know, or from the cell, come and answer in court. So what are these exceptions?
All right,
break them down for us to understand.
All right, now the combination of Section 35, which is personal liberty, and also Section 36, it talks about freedom that you enjoy, is that you can't be hounded, except, now we go to the exceptions.
Okay.
The exceptions are, one, if it's pursuant to a court order, where an order has been given that this person should be brought to court for prosecution for a criminal case, that's one. Where there's a communicable disease being spread or likely to be spread by that person, then the person can actually, your personal liberty can be withdrawn. Then also, in respect to education, particularly for a minor, your personal liberty too can be withdrawn because you have to be educated, because part of the law, or the law also recognizes the need to educate its citizens. So if you have a kid who wants to just go on its own, I don't want to do this, the law permits that its a personal liberty be curtailed. Now, so those are the things that also, in certain instances, majorly it has to do with courts. It has to do with court issuing an order or pursuant to an arrest. Now, where you're likely to commit a crime, or where you have committed a crime, in those areas, your personal liberty will be curtailed. Now, then you go to the law, you go to the court, then you face the court, then you are also entitled by law to get a lawyer. In fact, the law provides the same, Section 35, going on to 36, says that where you are arrested, that you have a right to be silent until you get a lawyer to come to your aid. Now, to your question, where somebody is being arrested based on what we've established, the law provides that that same person must be charged to court that same day.
Okay. Within 24 hours.
Within 24 hours.
All right.
Now, the law says within a reasonable time.
All right.
Now, but this is how it works. There's another provision of the law following that 24 hours that says that where a court is not within 40 kilometers, or where arrest is done, maybe later in the day, there's no court sitting at night, then they have to wait for a certain period, but it has to be maybe within 48 hours or within a reasonable period of time. Now, that is as far as that goes. Now, there's the Administration of Criminal Justice Law, which also permits some of these prosecuting authorities, certain times, when they arrest someone, particularly where the person has just committed a crime and some things are still hazy. Now, there's a provision of the law that allows that authority to go to court and get an extension pending investigation, but it's never more than 30 days. Because if you have arrested someone, the law already provides that this person must be charged to court. Now, but if your investigation is still ongoing and you suspect that releasing this person on bail is a flight risk, or he cannot just bail out, then the best thing is to go to court. You can't do that on your own, holding him down. You have to go to court, and by bringing certain applications to the court, then you get an extension to hold this person down pending investigation. Then eventually you bring him to the court for prosecution.
So only the court has the right to issue an instruction or extension of holding someone,
absolutely,
while the person is coming to court to answer for whatever.
Yes, because the premise is you have to be charged to court within a reasonable time, 24 hours, 48 hours, wherever the court is located around you. Now, so where that happens also, but when investigation is ongoing by the prosecuting authority, they need to go to court. If they're going to flout that part of the law or extend it, they can't do that on their own. Though we've seen instances where they've done that, but it is ultra-vires. It is against the law, and they can actually be held down. In fact, the Constitution says that you are entitled to bail. There's administrative bail, which can be given to you within them. Then there's a bail that you can actually go to court and get, and then the court will allow you to go on bail pending the prosecution
when,
of your
when
case.
they talk about bail, sometimes we hear of bail conditions where you need to get someone who has either landed property in certain cities and then some amount of monies. And is it the discretion of the judge to decide what should be the conditions?
You know, there are two kinds of bail. There's the administrative bail, which can be given to you by that prosecuting authority, like EFCC, NDLEA. Sometimes they invite people. The invite often doubles as a warrant of arrest. Now, so once they've listened to you and quizzed you, then they can allow you to go where they feel that. So that's like the administrative bail. Then you come to the court. There's the bail that comes from the court, which the court, now in that instance, sometimes too for the administrative bail, the essence of asking you to bring somebody that has a landed property or a civil servant or somebody who is, well-to-do, that has some connect within the society, is that where they suspect that, I mean, we've seen instances where people can actually just jump bail.
Of course,
and some people can go as far as, we've seen somebody jump bail in the UK dressed like a woman come to. Now, so to avoid things like that, that's why they say, okay, bring certain sureties. In fact, all those things are provisions in the Constitution. So you can they will ask for certain sureties, and then the sureties are supposed to stand in for you. They're supposed to be credible people who will stand in for you. So where you jump bail or where they can't find you, they call the surety, then the surety will produce you. That's how it works. Now, so that's as far as bail goes. But there's certain, coming to where we're going now, that there are certain instances, I told you about the essence of the law. It's not to persecute, it's to prosecute and get to the end of the thing. Now, there are instances where, now coming from the premise where you're presumed innocent until proven guilty, there are instances where people genuinely fall ill, sometimes in detention, and they need medical attention. Now, when that is brought to court by the lawyer or by even the prosecuting counsel, then the court will look at that circumstance and allow that person to go, because the essence is not to kill you. The essence is to establish the crime and punish you for the crime, not necessarily persecute you for that crime. Now, so because the law is liberal in that regard, over time, with all due respect to my constituency, the legal practitioners often explore that angle and also exploit it to the extent that we've seen where people prepare certain individuals and then they cook up. There's an ongoing case where, a prosecuting authority actually alerted the court that somebody, a prominent Nigerian, who produced a medical report, they found it to be fake. And that's in fact, that's like a little departure from what has been going on. Now, so people have over time exploited that angle where they'll make you come to court, make you look like you're saying some forged medical reports. Now, normally you can't say, you don't understand or you don't know what somebody is going through. And, sometimes I can tell you for free that where arrest comes, it triggers, emotional outbursts.
Yes.
And sometimes somebody who is hypertensive, that can actually trigger it. It's normal. It's something, it's a given. Now, but over time, we've seen people come up with funny things. We've seen people come to court with crutches. I mean, I think we grew up knowing a particular joke where somebody came to court and said he was, he's sick, he's this, he's that. Then the judge asked, so what happened? He just threw the crutches down and he was describing for the judge. And the judge was able to say that, come on now. No, this is not how it works. Now, so, but you see, so, in certain instances where the court finds out that you're trying to arm twist the law, or you're trying to lie and find your way out of, easily by using sickness or feigning sickness, feigning illness, then that in itself is an offense that is different from what you came there to do. And I think that should be frowned at, because in as much as we're trying to fight corruption, we're trying to clean the stable, because we can't lie to ourselves. Things are not too well with the fight against corruption. So lawyers or actors in the temple of justice should not be aiding and abetting crime. this thing should be frowned at. Now, people will come to you, they will dangle a lot of money in your face, but that is not the way it should go. The actors in the temple of justice are supposed to be noblemen, and they're supposed to be credible individuals, and they're supposed to actually point things like that out to the court and make sure that we don't go in that direction.
All right. When someone who is supposed to stand trial, when he provides a medical report, is it taken, okay, you provide a medical report, so let's act on it, or there's a way to make verifications in the face of the realities of some of the drama that we've had or seen in the last few years? Does the court carry out a background check to verify those kind of medical reports?
Prior to when the whole drama, using your expression, came, you know, normally when you produce a medical report from a credible institution, there's the presumption of regularity, that this thing is issued by the right person, by the right authority, and in the right circumstance. Now, but over time, when the court noticed this drama, now they go and verify. In fact, they verify your surety, they verify the property, because I've seen, I practice, so I've seen things, I've seen people come with clone titles, I've seen people, you just ask a simple question and you know the person will just fall off. Now, so over time, the court has taken, now, though there's an angle to it where sometimes verification can actually take longer than necessary, but you can't blame the court, because where somebody brings a clone title or a fake medical report and you allow the person to go, before you know it, the person has gone beyond Russia, or you find the person. So it becomes difficult, and then the court now looks incompetent. So what the court does now is they verify everything and make sure that this person, you know, you can't tell sometimes sickness, certain illness from the face. Now, but you have to go, then you have to establish a pattern. Because I've seen in recent times, somebody who was hail and hearty, somebody who was arrested at a party, all of a sudden, he gets to court, is being prosecuted, then he has all kinds of diseases in the world. Then by the time he's released,
all at the same time,
the same person goes back to his regular living. Then you know that this was a sham. This is not how it should be. So that's what we have.
All right, we have to leave it here now. Thank you very much. I'm glad that the courts are looking in this direction, because a lot of cases that need to be, you know, foreclosed and then, you know, prosecution to be concluded sometimes get delays because of this, and I'm glad the courts are looking into ways of handling that. Thank you so much, Olutumboso Oshufora, for coming on the program.
My pleasure.
Great.